Good Saturday afternoon and happy Easter. Carl Rominger here answering your legal questions. And before we get into the show, I'm going to probably pop this out a couple times here. Camp Koala, it's a bereavement camp for kids who've lost a parent or other important person in their life. They have a week running from May 20 to May 22nd here, 2011. And I was told when I was in Rodabaw's barbershop the other day, who did a great fundraiser for him, that they're looking for some eggs. And I got confused and thought, well, it's Easter. They must be looking for Easter eggs. And no, the answer is the camp runs from May 20th through the 22nd. And they were looking for a chicken farmer who could donate between 15 and 20 dozen eggs. They thought they had somebody, but that guy's out of the chicken business. So here's my question. If anybody out there knows a chicken farmer, is a chicken farmer, lives near a chicken farm, contact me off the air on Facebook on Weekend Appointment, or just call in here to Shane. And if you're willing to donate 15 or 20 dozen eggs for these kids, that would be really a nice thing. So I'm going to kind of shout out here and see who can step up, if anybody, because I don't have any chickens, although I did once raise a good number of them. They were not laying hens. They were broilers, so they wouldn't have been much good anyhow. 540-0580. Call in with your legal question. We'll answer them here on the air. Also, I want to remind you, go to weekendappointment.com. We've been answering questions on there like crazy the last few days. We also have a bunch of special reports up on there. We have one, are my Facebook postings private? If you've ever wondered about what's your privacy rights in your Facebook postings, we give you a little primer on it. I can tell you they're not good, but just it gives you a little understanding of why. A lot of people think that their postings are not public because they've restricted who can see them. But for purposes of court, you're going to find that they're actually considered public, even if you think they're private in most instances. We also have a report up there, can the police search your car roadside, and do you have to talk to the police? And if you ever wondered, what are your rights roadside here in Pennsylvania when you're pulled over, well, we got them right up there on the front of weekendappointment.com. We've also got a great discussion on the difference between tort and limited tort insurance. Fred, you're on WHP 580 with Carl Rominger. The talk line number is 540-0580. What's going on, Fred?
Yeah, Mr. Rominger, I visited your offices in Carlisle there, and I was talking to a Mr. David, and he never returned my phone call. I spent about an hour with him explaining everything, and he didn't return his phone call, and I've also visited your office.
Now, Fred, I think you're and I got to drop you because I think Fred's mad at us. And I think it has to do with the fact that Fred is actually somebody else who WHP is banned, and I don't know how Shane let him through. Oh, he's laughing over there in the booth. You didn't catch that, Shane? No, you didn't catch it? I don't know. For some reason, that caller, who usually goes by another name, has been told he's not allowed to call here, which is not my rule, but I think he's mad at me because Shane wouldn't let him through the last couple weeks because there's something going on here. Apparently, if you call too often or if you ramble too much, they put you on a banned list. So most of you should be able to get through that. 540-0580. That's the talk line number here on our Saturday before Easter. What else did I have going on? Well, I did have somebody wanted to know about the Divorce Master System post on weekendappointment.com. And just to give you guys a little primer on how that works. In the Divorce Master System, when you file divorce here in Pennsylvania, you don't generally get to go see a judge to resolve all your problems. Instead, the courts have created this special post who's a lawyer. Not some counties, they still use judges for this, but in most counties, there's a lawyer who's either a full-time master or takes appointments as a master, and they act as a hearing officer and decide the splits. And the master's process can be lengthy. And so when you guys have some specific questions, I'd be happy to answer them about that. But here's one thing I've been telling people is, you can write letters back and forth and negotiate with the other side. And what ends up happening is you don't list it with the master, and it's a year down the road, and the negotiations have not gone well, and suddenly you want to go see the master. Well, the master's process is not instantaneous. You've got to file inventories. You've got to do pre-hearing statements. You've got to do a lot of work to get in front of the master. And so I usually tell people it's about 6 months from the time you're sure you want to see the master until you're probably going to get any kind of resolution, and then that can be appealed. Sometimes it takes longer than a year. So I'm advising clients more and more these days in divorces to take a slightly more aggressive stance and file for the master immediately when the case is first filed, and making it clear to the other side that we're not disinterested in settlement, and in fact we're hoping to settle the case. We just don't want to end up in that position. I'll bet you a lot of you listening out there who've been through a divorce have had this happen, where your lawyer and you've written letters in good faith back and forth. You thought you were negotiating or trying to negotiate, and you get a year into the divorce and you still haven't resolved anything. You don't know who's going to do what with the house. You don't know about the pensions, and there's a hang up, and then you have to litigate it anyhow. And so what I found is putting that imposed deadline out there. In other words, the proverbial, do it or else deadline out there creates a situation where the settlement will occur, if not before that hearing, close to it, if there's going to be a settlement. On the other hand, you flush out the fact that there's not going to be a settlement in your divorce, and then you're able to get resolution a lot sooner, rather than discovering that the case can't be settled 8 months after you've started and still not move the case along in any meaningful way. So that's just a thought on the divorce. Obviously, if you have a lawyer and working with one, you're going to want to talk with them and see what they think works in any particular case. But that's been my trend over the years. I just found too many times that we would go back and forth, as you can imagine, with all these letters and all these promises for one another. And then all of a sudden, nobody can agree on anything, and there's no pressure, there's no moral reason to agree, and more importantly, there's no angry judge or master saying, come on, knuckleheads, you guys are about $10 apart. How come you can't agree on that? Talk line number here is 540-0580. You want to talk about the law? You want to talk about any other issues? What I see, weekend appointment, I also had an IRS question, which I usually tell people, go taxes is not for lawyers. The question had to do, though, with who can claim kids in a divorce. And what I did was post a response on there with just the IRS's link on that. They have a series of priorities. But as a general rule, if two parties can agree, whatever you can agree on works. Otherwise, it's who they're with primarily, or who the, quote, custodial parent is. And I can tell you that in a lot of cases, in child custody cases, support cases, if the parties are somewhat amicable, we will send them to the Liberty Tax guy or the H&R Block guy or whoever they're going to go see together and say, try filing your taxes, whichever the alternate ways you want. So one of you declare 2, one of you declare 1 and see what the numbers are. One of you declare 3 and one of you declare 0 and see what the numbers are. And sometimes you can push a dependent back and forth to create a situation where both parties get more money combined, whereas by way of example, some people, whether it's 2 deductions, 3 deductions, or 4 deductions for kids, it doesn't really affect their bottom line. All right, when I get back from the break here, we'll talk with Skip, 540-0580. See you after the break. All right, I'm back, 540-0580. Carl Rominger answering your legal questions here on the Easter weekend. See, we don't take a break because we know you probably have, your problems don't take a break. So here we are answering them here live on the air. And, of course, if you need us throughout the week, go to weekendappointment.com. We have the Harrisburg office up and running now. It's on Pine Street. I posted some pictures of it on Facebook. If you want to take a look, just go to my profile. They're publicly available. Or if you friend me, you can get them as well. And we're going to be staffing that on a rotating basis and as needed, but we're going to have people over there at least a few days a week. We have the Lancaster office. We've got the Chambersburg office. And, of course, we've always had the Carlisle office. And again, one more shout out here. If you're an egg farmer, somebody has a bunch of chickens who can get us 15 to 20 dozen eggs for Camp Koala. That's what I'm looking for here this weekend. It would be a charitable donation. It would be much appreciated. It's a camp for kids who have bereavement issues, who've lost a parent or a sibling or primary caregiver. And it's really a wonderful thing that you could participate in. And they need eggs. Skip.
Hey, good afternoon, Carl. Carl, in regard to an individual mother that's going to have a hearing before children and youth insofar as proper upbringing of her daughter. Are they allowed to have counsel with them? They
are. Now, I can tell you that in some counties, if they ask for it, the court will appoint them counsel with almost no questions asked.
Okay, this would be Cumberland County.
Okay, and usually in Cumberland County, they will provide counsel if they want them, no questions asked. On the other hand, they're allowed to bring anybody they want if they choose.
Okay, so if they choose to bring a lawyer of their own and pay for it, that's fine.
Correct. And in fact, over the years, and I got to be honest with you, over the years, we haven't done a ton of those except when we've either been court appointed because one of the regular attorneys wasn't available or something, or somebody's privately hired us. But for the most part, a lot of folks who obviously are facing children and youth issues, not all, but tend to fall in a lower socioeconomic income bracket where they generally don't have, lawyers at their beck and call. And so as a result, there's not a big thriving private practice in that area, but it is certainly a body of law that myself and certain other practitioners know well enough to go in and do. It's a little bit different than child custody because it follows the dependency statutes.
I see. But in any event, regardless of what the situation is, it's always advisable to have counsel there because it's to your benefit, I would think.
Yeah, in fact, and I can be, listen, here's the answer. I don't think you should ever be in court without a lawyer if you can possibly avoid it. And if somebody's going to give you a free one, a public defender, a court-appointed counsel for a matter like children and youth, or even mid-pen legal for something like that, those attorneys had to take the same test I had to get, from A to B. And as a result, general level of competency is very high, particularly in this area amongst court-appointed counsel. I have actually been to a few nether areas of the state where we've been a little circumspect of court-appointed counsel. But around here, most of your court-appointed counsel is good as or better than what you're going to get by retaining private counsel. Because here's the example, just what I was telling you, like children and youth work. There are some attorneys who do a lot of the court-appointed work in it. They have more expertise because they just have more practical experience.
I see.
Some public defenders are better criminal lawyers than private criminal lawyers because, again, they have more practical trial experience than most criminal lawyers. I've been blessed to have a lot of trial experience. I can tell you a lot of people out there in private practice that are criminal lawyers don't have nearly the trial practice that a 10-year private or public defender has. Now, back to your point, though, yes, it's always better to have an attorney, particularly when you're dealing with something serious as the custody and or welfare of your children. And in a dependency action, you could actually lose your children permanently.
Right. Okay, thanks a lot for your help.
All right, Skip, thank you. Yeah, folks, if you ever get a knock on the door from children and youth, you're going to want to deal with that very seriously. I also have clients that get themselves into little tangles because children and youth also get called a lot of times when the police are investigating you for neglect or abuse or sexual abuse. And people get scared of children and youth and they think they have to talk to them. Well, anything you say to children and youth can and will be used against you in the criminal proceedings. So a lot of times what you want to do is retain a lawyer like myself who knows the criminal law as well as the children and youth law, and we'll work our way through that minefield. And there's ways to do that where we can deal with children and youth and deal with the criminal authorities, avoid having you give a statement because that's just the way we operate usually as criminal defense attorneys, and at the same time protect you vis-a-vis the children and youth authorities. 80% of all children and youth complaints come back unfounded, meaning that there's a pretty good chance you're going to be cleared. The problem is you're just never sure if you're going to be one of them up front, even if you didn't do it. John, you're on the air.
Yeah, Carl, I have a question regarding something that it's in front of a judge, and what they're saying is, we're going to have to now, my attorney is saying, I talked to his paralegal last week and saying, well, we're going to have to put a petition together to compel them to go to arbitration. Then she said it was a motion to compel them to go to arbitration because the other side raised all these other issues, and they said, well, that should be an arbitration.
Right.
Now, what is the difference between a petition to compel arbitration and a motion? Does it matter since it's in front of a judge, or which one is used?
You're hitting on one of these funny ones. Difference between a petition and a motion. I actually wrote a. I'm laughing about this. A North Carolina Court of Appeals, and I'm just pulled up on the web here, something I actually wrote about this a while back. Motion is a written application requesting the court to make a specific ruling or order. A petition, a written application requesting the court to make a specific ruling or order. There is no practical difference between a petition or a motion. However, the Sixth Circuit Court of Appeals has said there is a difference between a motion and a petition. The answer is, for all practical purposes, most lawyers will tell you they're really not different. Now, here's the one thing that people have said. A petition is a standalone action and a motion is part of an action. So every once in a while, you'll have a court that says there's some difference between the two. So what clever lawyers like myself have done is styled something and we call it a petition/motion to compel arbitration, or petition/motion to fill in the blank. And that way, if you do run across a judge or a court that seems to think there's a huge distinction, whereas, like I was just pointing out to you, like the North Carolina Court of Appeals doesn't say there's a difference, where the Sixth Circuit thinks there is a little bit of a difference.
Oh, okay, I see. So if they say petition and motion, then all right, I understand from what you're saying, and that makes sense.
There's no huge difference between the two in the practical effect, and that's why I say sometimes we style it as a petition/motion just in case you run across somebody who wants to say, well, you should have filed a petition, not a motion. You're like, all right, just ignore the first word in my title there. I know that sounds sloppy, but the answer is it's a common problem because there is, in some jurisdictions, a huge interest in the difference between the two, but for all practical effects, if you file it one way, they'll usually treat it the right way.
Okay, then thank you very much.
All right,
Bye-bye.
Take care. Yeah, I wrote a little ditty about that a few years back because we just came back in 2007, came across it and just wanted to put that up out there to see what people had to say. And I can tell you the general rule is a motion kind of happens in a case that already exists. So you're making a motion, it's internal to the case. A petition can be a standalone thing. However, quite often in motions, people will call the person making the motion the petitioner. So, I don't know. Maybe he's just the moving party. 540-0580. If you guys have legal questions, you want to get them answered for free here on the air today, this is the place to do it. If you're looking for an attorney, you just call us off the air and we'll take care of you. Go to weekendappointment.com. You can claim those free wills. And don't forget about the free will program. We still get a lot of those in. You download the will. You fill it out. You send it in. You get to meet with me. Sometimes one of the other lawyers in the office if I'm not available. You can always meet with me if you want to. Every once in a while I get called into court. But the idea is you meet with a real live lawyer and we go over it together in depth. So it's not just one of those free wills. It's not just a form you fill out from the Office Max or the Staples, where all you're probably doing is creating more heartache and terror for your family later when it turns out that you've somehow given the same thing 3 times. And if you haven't ever looked at the cases out there, when you do the legal research, there's tons of cases with people who did their own will, and they thought they were doing something. And I'll give you a common mistake. I leave my 91 Ford Mustang to Shane Allen Clark. Well, when I die and I've sold my 91 Mustang and bought a, 89 or something like that, in my mind it's the same thing. I wanted him to get my Mustang, and I'm sure that's what's going to happen, right? Well, the court's going to say, no, you named a specific vehicle. And by naming and identifying a specific vehicle, that gift lapses, and we move on through the will, and we just cross it out like it didn't exist. So maybe a better way to write it is, I leave Shane Allen Clark my Mustang, or any Mustang I own at the time of my death. Then he gets any Mustang I own at the time of my death. But maybe I just decided I didn't like Mustangs anymore, and I wanted to switch over to, like the IROC Z or something comparable. And then I put any Mustang, well, it's still going to lapse. So maybe I should say any collector's automobile that I own at the time of my death. And you can see that there are better ways of phrasing things depending on what you want to do. Or you might actually want to make it a specific car, and you kind of thinking like, my one son, he really likes Mustangs, so I'll leave him any Mustang I own at the time of my death, but he doesn't really like the other collector's cars that I'm into. So I'm intending that if I no longer own a Mustang, that he doesn't get one of my other cars. And these are all the iterations we have to go through when we're writing a will to make sure we're doing it the right way. And that's just one class of property and one type of situation. And if you think that you're doing it right by filling it out yourself, a lot of times you're going to find out that's not the case. 540-0580. Mike, what's going on?
Yes, sir. On power of attorney.
Yes.
Is the power of attorney, when it's given, is that person responsible for any debt that in case I can't pay or and so forth?
Repeat that for me. So I
Okay. If I incur debt,
right,
and I assign a person a power of attorney,
right,
would they be responsible for any debt that I incurred.
No. When you make somebody your power of attorney, all you're doing is giving them the right to transact business in your place. They are not becoming responsible for or any way. Neither are they entitled to your assets nor your debts.
Okay.
They can just do anything they want with them depending on how the power of attorney is written. So a classic example is, if you have a credit card bill and you give me a power of attorney and you're in the hospital, I can pay your credit card bill. I can deposit your most recent paycheck. I can sign for your UPS package. I can cancel your lease with your landlord. But all said and done, no, I don't become responsible for your debts.
So that you can't. So the debtors cannot go after the power of attorney person.
That is correct. And you know what? That's a common mistake we see sometimes when people represent themselves. Now, as the power of attorney, you just have to be real careful because, to give you an example, these nursing homes love to do this one.
Yeah.
They'll say, hey, Mike, you're the power of attorney for your dad. Well, while you're here, can you sign as the responsible person? You have to be real careful that you're not signing as an individual, but as the power of attorney. And I've seen them where they suck you in, and then you're now on the hook for the nursing home bill because you not only signed as the power of attorney, but you also signed as a guarantor.
I got you. Okay. Well, I appreciate that, Carl.
All right, brother. I got to go to break. Thank you. Happy Easter.
Bye-bye. You too.
540-0580. See you after the break. Hey, welcome back. 540-0580. The show where we answer your legal questions here at WHP 580. I'm an attorney here in the mid-state. Got jury trials starting in Cumberland County on Monday, although I'm already getting the whiff that they really don't want to try it with me because I think out of 200 cases on the list, I'm dead last. And I always take that to mean they're not anxious to have a trial. Usually they like to put me up first just to work me. Make sure I'm up Sunday and working. But obviously that worked out real well because now I don't have to do anything on Easter except crack some eggs, right? 540-0580. Jen.
Yes.
What's your question?
My question is there any way to have a charge of a possession of marijuana expunged from a record? This would be like a young person who, made one mistake, and now that charge is with them for, I guess, forever, and it's just ruining employment opportunities. And I'm sure not just for this person. There's probably lots and lots of people in the same position. Is there anything that you can do about that?
Well, the short answer is if it's a Pennsylvania charge, a misdemeanor or a felony in Pennsylvania can never be expunged unless it's pardoned. And to get a pardon, you have to go through the Board of Pardons. You have to get a unanimous vote, and then the governor has to sign it, okay?
Yep.
And almost all the pardons are conditional upon you not expunging it. So it'll show on your record as well, let me put it this way. It won't show as a conviction on your record any longer. But if somebody really digs, they're going to be able to find it, and they're going to be able to see that it was pardoned, meaning you did it. Now, Pennsylvania does have some laws about what can be held against a person in their criminal background, et cetera, and there's supposed to be some rational relationship between the crime you've done and et cetera. But, yeah, it screws you up for nursing. It screws you up for being a school teacher, and I can just go on and on from there. And a lot of employers simply look at a criminal background, and even if they don't write you in the letter and say that's why we didn't hire you, if they got 7 applications, it's always safer to take the person with no criminal background because that way you don't have to worry later about somebody arguing, why'd you hire this person?
Right.
So the short answer is there's nothing practical to do about it. Now, 2 things. How long ago was this conviction?
4 years.
Okay. So we're probably well past any timelines to reopen the conviction. I'm sure of that. And the only thing I can tell you is that, is this a teaching moment for everybody else out there? If your kid is charged with a minor crime of marijuana possession or paraphernalia, or some other even similar crime or disorderly conduct or a bar fight, and you want to be one of those parents who goes, well, my kid did it, he could do the time, and he can learn his lesson. Yeah, except that 25 years from now, your kid's still going to be learning his lesson. And last I checked, when you spank a kid, You don't spank him once a week for the rest of his life because he stole a cookie when he was 5, right?
Right.
And that's where the public seems to get a little disconnect, that this is such a great idea. And I know there's some hillbilly in a truck out there right now, probably one of my hunting buddies, going, well, Carl, you know how it is. You risk it. When you do it, you risk that. Well, they're the first guys when it happens to their kid to come in whining and moaning about, what do you do? What can I do? The good news is, at least they come in whining, what do I do? Because then a lot of times we can get the kid into ARD. We can do other things to avoid the charge, or we can change them into summaries, which can be expunged after 5 years in Pennsylvania now. That's a recent innovation.
Mm-hmm.
So it's not going to help you or your friend or this young person, but I think everybody out there, if you have a friend or family member who's charged with a crime, I can't count the number of times somebody comes in because they want to take their kid hunting and they inadvertently gave up their gun rights 20 years ago because they didn't realize what they were pleading to, even though it didn't carry any jail time in their mind, and they didn't go to jail, and they may have only paid a fine, and they might have only seen a judge once. They might never even been arrested. They just got a piece of paper in the mail, has lost their gun rights, has lost their ability to be a commercial driver, has lost their ability to be a school teacher, has lost their ability to be a nurse or a doctor. And a lot of times these consequences aren't obvious because when you're 17 or 19, you're like, yeah, who cares? I'm not going to do that anyhow.
Right.
And then later in life, as you get your act together, and the real tragedy of all this pot stuff is, it's all going to be legal. In fact, I said in court the other day, and the court reporter chuckled. I think the judge just let it go, but I said, well, can I continue this a year or two till we see if it becomes legal?
Well, there's another question. What if it becomes legal? What happens to all those people with those, misdemeanor crimes on their record?
You still got a crime on your record because you still broke the law. That's what people are going to say. Now, I would hope at some point, like we did with in the 70s, because of the racing, all the muscle cars, that was the epidemic of the time, was muscle cars. So the legislature had to do something, so they made racing a felony, because that's the legislature's solution to everything, make it a felony, right?
Yeah.
So they made racing a felony. Now, there were a whole bunch of guys out there who paid the police officer would pull you over for racing. You would go see the district magistrate, and you pay your ticket, and you would have a felony on your record. So the legislature, a couple of years back, passed a law that regraded any offense for which was a misdemeanor or a felony under the vehicle code, which is now a summary, or the equivalent offense is a summary, has now been retroactively regraded to a summary. So I would hope that at some point when marijuana is legal, and all the people chuckling at me saying it's not going to be legal, I could care less if it's made legal or not. But what I'm saying is this: it will be made legal because the table games are not paying off the school taxes fast enough, right? And in fact, I'm just chuckling too because one of the guys I know was like, so my $1,600 school tax bill is getting reduced by $200. I thought they were going to pay the whole thing with the gambling revenue. My point is the government's going to eventually legalize marijuana in this state, and they're going to do it everywhere else for a revenue stream. And then hopefully the legislature will have the courage to say, you know what, let's reclassify all these marijuana things as civil infractions or something.
Yeah. Well, I'm not a great proponent of marijuana use, but I think the punishment far outweighs the crime, on an ongoing basis, affecting people's lives for so long.
Listen, let me tell you how screwed up it is, okay? If you beat your wife or your husband or your kids, not too bad, not an aggravated assault, but, you just give them a little punchy and do a lot of other bad things to them. You get a whole pile of misdemeanors charged. Tell them you're going to kill them, and you get a misdemeanor terroristic threats. You'll get a misdemeanor simple assault. You try to run one of them over with the car backing out. You might get an egg assault, which would be a felony, but let's just say you just peel out. They'll throw in a reckless endangerment. You go out and you shoot 3 deer in one evening, and the game commission will have you charged with a felony. So I always say, only in Pennsylvania does shooting too many deer in one evening make a felony, but, as long as you just don't beat the wife and kids too bad, you'll just get a pile of misdemeanors.
Oh, we got to change it.
So, but that's the problem is here's what happens. See, the recent laws are the deer laws, is poaching laws, and that's the legislature's solution these days. Felonies. Listen, our state is going to go bankrupt, and one of the reasons our state, California, New York, Michigan, Illinois, and everybody else are going bankrupt, right now they're blaming the public employee unions, and that could be part of the problem. But has anybody looked at the prison spending recently in these states? It's astronomical. We're going to cut education in Pennsylvania, but we're upping prison spending.
Yeah.
And why? Because we've got non-violent drug offenders who need to be locked up for as long as possible.
Yeah. Well, like I said, I'm not really, in favor of.
I'm not either.
Making marijuana legal, but you know what? How can I go ahead? What could I do to push this?
What did Bob Durgan and I have a discussion about one day was this. I said, Bob, pot's illegal. And I said, well, Bob, I understand that, but I can't imagine how we can rationally say that alcohol's okay, but pot isn't. There's no rational difference between the two. So if you're going to let the public dose themselves with an unnecessary drug, why is there caffeine in soda? It's an additive, right?
Yeah.
It's there to give you a little boost. Now, the energy drinks, now all of a sudden, oh, no, what about the energy drinks? The answer is, we let people do what they want. Now, on the other hand, you can't get a life-saving drug that's experimental. So if you have cancer and the doctor says you don't qualify for the trial, you are going to die, but we could try this new experimental drug on you, but you don't qualify for the trial. Our good Supreme Court said the government has the right to keep you from getting it, and the doctor can be in trouble for prescribing it. But, again, you are allowed to go back to the liquor store and buy 2/5 of whiskey and take it home with you and drink all of it in one sitting. That's legal.
Yeah.
All right. Sorry about it. I know I'm ranting a little bit, but...
No, that's fine. I appreciate your answer. I was hoping for something different, but,
Yeah, and so the teaching moment, let's go back to the teaching moment here. Folks, do not let your kids plead guilty to crimes. Do not plead guilty yourself. Make sure you are fully aware of all the long-term collateral consequences. The courts have said that you don't have to be informed of them for your guilty plea to be knowing, intelligent, and voluntary. So when you stand up there in front of the judge and say, yes, I'm guilty of smoking a joint, or yes, reckless endangerment, or yes, a DUI, nobody has to warn you about the driver's license losses, the career problems it's going to create. You're not entitled to any of that. Weird thing is, an illegal alien is entitled to be informed about how it will affect his immigration status.
No. Well, thank you.
All right. 540-0580. We'll be right back after the break. Oh, yeah. 540-0580. Carl Rominger answering your legal questions here. And, of course, you all decide to call in at once. So we'll take you as fast as we can here, guys. So we're going to move through this. Let's see. First up, Dave.
Hello.
Yes. How are you?
Carl. I'm calling you from Western Franklin County, and I couldn't agree with you more about the legislature's tendency to make everything a felony. That's one of the big problems. The legislature can't say no to any special interest group that comes in with a request to up the penalties on a lot of things, and they don't see it from the standpoint that you see it from, and that the court system sees it from. One of the main culprits, as you pointed out, is the Pennsylvania Game Commission. And as you rightly identified, you can get yourself in a lot more trouble for a deer kill than you can for an assault. This is also true for animal cruelty. If you beat your dog, you're going to get a first-degree misdemeanor and go to jail for up to 5 years. But if you beat another person, it's only a second-degree misdemeanor, and you might even be a third-degree, and you could only go to jail for a year max.
Right, and of course, Dave, if the legislature simply said, let's roll back and just make a dog like 1 year max instead of a misdemeanor of the first degree and put it below simple assault, the dog lovers would come out of the woodwork and say, well, you're anti-dog. And
right.
So the only solution, right, is to make beating a person carry 100 years in prison, because that's what that would be the only answer the legislature can politically palate. I hate to say it, but every once in a while you understand why a dictator has the ability to do things a little bit better than democracy, only because, like the Chinese can actually just sit down and go, well, we're in charge. We see the problem, so we're just going to change the law, and we don't care what the people say. And
what you're saying needs to be said, because the people need to realize that a lot of these enforcement agencies, and the Game Commission is one of the worst examples, they write their own law, and the legislature simply rubber stamps it.
You know what? The
dum-dum idea in a lot of cases, the ramifications of these things that they allow the rulemaking bodies at the state to push through.
I saw the new game law that makes it a felony for poaching deer is so poorly written, and I don't care who wrote it. I'd love them to call me up and I'll.
But
tell
nobody
them.
questions them on it, Carl.
I know, and here's the deal. Here's the deal. That you're right. They wrote it themselves, and one of the things they missed is because I always joke that game law wasn't real criminal law, because it was just a bunch of summaries.
Yeah, but it really is.
It now really is. And what they didn't do was study all the criminal cases that have come out for the last 20 years, which inform how you have to write legislation. And so there's something called an Apprendi issue, which has to do with the fact that the maximums change based on certain factual findings, so you're guaranteed that it has to be a jury issue. Most legislatures, when they're writing good criminal legislation, are careful to avoid creating Apprendi issues because it makes the sentencing and the prosecutorial end more streamlined. It's just a basic mistake. Anyhow.
Well, I'll just leave you with one last thought. Down here in western Franklin County, we have a magisterial district judge race, and we have a deputy game warden by the name of Jody Iyer running for office. And in his literature, he's putting down, if you do the crime, you should do the time. Now, isn't that a great thing for a judge to say?
Yeah, and in fact, that's the other problem is right now, in order to be elected, you have to say you're going to keep kids safe and stop crime as a judge. That's not what we hire judges to do. We hire judges to be the neutral in between. The judge's job, listen, if the district attorney wants to prosecute everybody, God bless him. That's his job. That should be in his campaign literature.
Well, the last time I looked, the office of judge at any level was to be just that, a judge, and not a rubber stamp for the enforcement agencies like the Game Commission. I think the people down here, I hope they're smart enough to see that.
I hope they are too. You know what? And the answer is, sometimes the judges have to be careful what they put in their campaign literature too, because they can use it for a recusal basis.
It's a violation of the canons, specifically the rules of conduct against campaign, governed campaign practice.
Of course, there's a whole bunch of stuff going on with the district justice races down there in Franklin County, isn't there?
Yeah, but I know what you're talking about. But the other aspect of this is that you get the Harrisburg. You get the Harrisburg fraternal organizations who are basically unions for retired cops and retired game law officers to get cushy benefits in terms of retirement and things like that, and they endorse these types of people, and that's pretty pathetic also.
And actually, what's the other thing, I'll just mention this again, a complete side note, but in California, who was behind all the expansion of the 3 strikes laws and a lot of the other stuff out there was the union for the guards. Actually got most of that. Helped, I shouldn't say, single-handedly, but they pushed it, made sure it got in and put in a lot of tough provisions. And, of course, nobody could vote against it. But what it resulted in was the prisons, the number of guards expanding by like 20-fold over a 30-year period. And their union, the guy that ran that union for years who did all that, he's like a hero to them. And it was a genius move. And that's what's happened in states like this, too. We can't have a rational discussion about shutting down prisons. The minute you do it, the District Attorneys Association, the law enforcement guys come out and say, you can't shut down prisons. You can't close the prison population down. And all we do is keep spending more and more and more money for a result that's not that great.
I hear you.
All right, Dave. I guess we're preaching to each other, and we're both the choir here.
Yep, great talking with you. I will leave you with one last thought. When you talk about people who are law and order oriented and so forth, and they claim to be conservative, a liberal is a conservative that just got his first speeding ticket. How about that?
I know that. All right, brother.
Okay, see ya.
I love doing that. Guy comes to my office accused of something he didn't do. And I can always tell when they're the Archie Bunker type, I'll bet when you used to read the newspaper home, you thought everybody was guilty. Yeah, I did. I guess now you're reconsidering. Yeah, now I am. Jack, you're on with Carl. Jack.
Hi, Hi, Carl. Enjoy your show, and I always love when you fill in for Bob, too. I have a follow-up question about that POA. I'm one of 3 siblings that have POA for my mother, who's in a nursing home. And you're right. Anytime they change care or their room, there's always this 30-page document they try to get you to sign. And you got to go in the middle to see that you're signing as a guarantor, not just as a POA. My question is, what if one of the other siblings signs one of those inadvertently? Does that make all 3 responsible or not?
I wouldn't think so. I don't think they can bind. I don't think they can bind you unless they cleverly had you sign something earlier.
Well,
cross-authorizing. And listen, when I put my grandmother, I moved her into assisted living at her request, although she later decided she didn't like that idea. And I had the meeting with them, and they're like, well, you need to sign here. And I'm like, no. And they're like, well, we'll have to put your grandmother out on the street if something happens. I'm like, no, you can't. No, you won't.
Okay, well, that's good to know. And I thought of another question now. Like,
all right, I got
now.
Jack, I got to go next week, brother. Sorry, Dale. Hey, guys, go to weekendappointment.com. We've got a Harrisburg office, a Lancaster office. We're always looking to help you. We got 5 lawyers to serve you. Go to weekendappointment.com. Call the office. Call Tammy. Call Linda. Say, hey, I need the boys to help me. We're here for you. And I'll see you next week.